Welcome to Next Round with the Pacific Research Institute. I'm your host, Romina Ichon. This week's discussion is on the California Consumer Privacy Act, or CCPA. Tim Anaya, PRI Senior Director of Communications, and I have a conversation with one of the nation's top experts on tech policy, Bartlett Cleland. Bartlett is PRI Senior Fellow in Technology and Innovation, and in this podcast, he discusses the CCPA's impact on consumers and businesses, as well as Prop 24 on the November ballot, which aims to provide consumers more control of their data. And finally, we also get his take on the role of technology and innovation during this coronavirus pandemic. Thanks for joining us. Welcome to PRI's podcast, Bartlett.
Well, thank you for having me.
So before we dive into the new California Consumer Privacy Act, or CCPA, talk a little bit about data privacy and the COVID-19 crisis. How has the pandemic affected data privacy and collection?
Well, it's certainly forced us to ask questions we may not have asked before COVID, or if we were asking them, instead of them being some ivory tower answer, now we have real live application, which has been interesting for all kinds of reasons. And I think highlights an important point about what privacy is concerned, particularly in context lately, which is really all about online privacy more than just, if I'm walking down the street and people observe me kind of privacy. And that is that two major things have happened. Number one, technology, broadly speaking, has performed extraordinarily well during the pandemic. So if you think about broadband connections, let's say, in particular, widely, some might have argued that there were people cheering for broadband to falter, that some of the big companies might falter, some of the bigger industries might falter. Turns out that the system has been and continues to be stressed, so to speak, but it has also continued to perform exactly as expected, given the specs that it was built to. So bravo. The FCC, regulatory agency that oversees a lot of that, a lot of the people in the broadband space, ask companies to step up and to not disconnect people and continue their same service plans, et cetera. But all that's gone very well. So that's on the one hand. Then on the other hand, or I should say it's point one. Point two is we have heard lots of talk about contact tracing. Interesting that it gets talked about so blatantly and brazenly. I suspect if we went back, I forget what month we're in here in COVID, but if we'd gone back, say, 6 months, I imagine if I told folks that I was interested in knowing everyone they talked to and everywhere they went and everything they did, and I was going to do that by looking at their mobile phone data that is being reported in the background, it's okay, for your good. I suspect if I'd rolled out with that argument 6 months ago, people wouldn't have been that excited about it. But yet here we are with a whole lot of people touting the value of that data. So take those together. You have technology that's performed very well, which means that ideas like contact tracing are viable during the pandemic. And I think we have a big discussion that's not happening, interestingly, on data privacy, somehow because it's lensed through the lens of COVID.
Bartlett, many state and federal regulations have been relaxed or suspended during the coronavirus crisis, including those affecting the online world. In your view, what recent temporary regulatory relief should be made permanent?
So I just read again, because I'd kind of forgotten some of the language that was involved here, but the White House so I think about federal, the White House in May did an executive order that asked agencies to consider relaxing any number of regulations. And their key consideration in that order, and I believe they'd done some before that, but their key consideration there was if it hindered economic recovery. Why in the world is it there in the first place then? And I laugh about it. I get there. Certainly we don't want people dying willy-nilly, child labor. I mean, there's all kinds of reasons that we have regulations in place, and some of them more valuable than others. But if it is so tenuous in its value that we of a crisis in the economy and say, well, this really is kind of hindering an economic, I think we need to hit the pause button. What relief from regulation should be made permanent? I kind of think if we were able to get by for the last 4 months without the regulation, has there been a calamity? Has there been a disaster? If not, those to me are the regulations that are front and center to be reviewed through the process that every agency has and removed. In fact, forget about the other side of COVID. Why don't we start now? Why don't we just permanently get rid of some of these regulations and allow, particularly the ones that are somehow hindering the growth? How about we get rid of them and have our economy grow ever more quickly so that everybody can get back to work and everybody can get back to providing for their families?
Bartlett, so we're so glad to have you here today because of your expertise to talk about California's sweeping new privacy laws, and they are very complicated. In fact, even during the COVID-19 crisis, with many businesses forced to close their physical offices for months, California, led by Attorney General Javier Becerra, remained firm in starting enforcement of this controversial new law earlier this month. For our listeners who haven't been following the debate, what exactly does the California Consumer Privacy Act do, and how our listeners have been affected by its provisions since the law began being enforced in July 1st?
I'm going to go in reverse order just because I think, particularly if we're talking to folks who haven't been following the debate, they might have noticed new pop-ups when they're online on their screens. They might have noticed new language when they make purchases or otherwise sign up for a website. And if they have, that's probably the biggest difference they have seen. And why is that? Well, largely because the law has been enforced now. I guess this is today would be week 3. So that's probably what they've seen the most. They probably have not seen more impact than that, frankly, because if companies hadn't changed what they were doing until 3 weeks ago, I don't think they would really see the difference. It's ostensibly designed, presumably, to protect consumers, but it's all about protecting a person's personal data.
Bartlett, you've said that the CCPA has, quote, doubled down on being inflexible. Many business owners and industry leaders have asked for fixes to the law, but their pleas were largely ignored by the Attorney General. So what are some of the specific problems with the CCPA that were not resolved before July 1st, and why, in your view, is Attorney General Becerra being so inflexible in the law's implementation?
There are a bunch of specific problems. I'm just going to grab a couple of the ones kind of off the top of my head. There are others that people have talked about or written about. Some are in the general application. Some are in the tactics that you might use to try to comply. But so one, I would say, and probably the biggest in my mind, compliance. Compliance is a challenge, not because people are unwilling, but because it's really difficult to know what the law would have a company do. And so why is that? Number one is that overbroad definitions, for the most part, have made it really difficult. In fact, the California organization that represents retailers, in fact, said we're something along the lines of we're going into this and we don't have guidance as to how we know if we're complying or not, which is challenging. I mean, a new regulation is challenging in the best of circumstances, in the best of times, much less if hard to follow, hard to understand, or not clearly defined. Ambiguity in the law is, frankly, money. It's money into the pockets of lawyers, and it's money not in the pockets of individuals. There's extraterritorial reach. What does that mean? Trying to reach outside the state with application of the law, how that will work, if it will work. Then there's some specifics. For example, how do you, as a company, how can you guarantee? Because remember, punishment is the backstop here. So you want to be really sure, if you're a company, that if you're collecting data somehow and it's occluded from view of the people working at the company, and they're putting all this data into a bucket for some kind of use. Here are all the people who like the color red. I don't know. How do you reach into that data pool and pull out the person who says, I no longer want to be included in that, even though they originally said, I want to be included? You have to unmask, so to speak, the data. And now you have exposed their information. Somebody's looking at that somewhere. And there's going to have to be some kind of list. There's going to have to be some kind of understanding that, yes, I've now removed that data, that I can prove to a third party if I were ever to be challenged on that legally. So some of it is the definitions, some of it's in the application, and some of it is in the breadth. And we put that all together, and I think you've got a whole bunch of problems. So begs the question, why is there such inflexibility? I'm always challenged in guessing what other people's motivations are. I think I would just say single track mind, as opposed to and maybe thinking more innovatively, more creatively about how do we, at the very least, you think the state could help with the compliance? If truly in their heart of hearts it is about helping people, then let's help people is what I would say. And that doesn't seem to be the approach being taken.
These new sweeping privacy regulations sound like they're going to be very expensive for businesses, especially now as they're struggling to make ends meet. What do the estimates say about how expensive the new CCPA regulations will be for businesses, and how much more expensive can we expect things to be for consumers thanks to the new law?
Well, there's one projection done by the state that says the cost will be $55 billion. Now, what I know is the answer isn't $55 billion. My deep suspicions will be more than that number based on projections. You're just destined to not have it right. And what we've seen typically about cost of compliance with laws, whether it's in California or around the country, is almost never is the state's projection of the cost adequate, much less accurate. And so very likely the cost will be much higher. But let's take the 55 billion just for having some number. That's a gigantic number. That's a huge number. And the expense to consumers is, I don't know, something pretty close to $55 billion is going to be the answer. Why is that? Well, companies aren't sitting on a trove of $55 billion that they didn't have anything better to do with it. They're going to have to get that money from somewhere. That means that whatever service or product they provided, the cost will increase. And that's how it ultimately get paid for. Business have to recover their costs. If they don't, over time, some amount of time, either immediately or longer, they will go out of business. It's kind of that brutally harsh. That seems to be what is lost, frankly, in some of the enforcement. Companies are already struggling to make ends meet. California is open, it's closed, and companies have to figure out how to maneuver those. And now they're being told, by the way, you have this gigantic new expense. And if you don't cough up the money for this expense, for this compliance, the penalties are gigantic as well. Could very easily run into tens of millions, if not more, even an average kind of breach of the law. Think about that as a small business. There's no way you can withstand that kind of cost. So you're really stuck between a rock and a hard place. I've got to spend a lot of money, or I've got to spend a lot of money.
Bartlett, on PRI's recent webinar on data privacy during COVID-19, you said that the original sin of California's new privacy law is the potentially significant impact it would have on future and ongoing innovation in the Golden State. So just how would innovation be negatively affected by CCPA?
Well, thanks for that. So there's a whole bunch of different ways. Number one, I can just go right to what we were just talking about. Wherever that $55 billion is coming from, there's a fair chance, think of your average product and just pick anything in your mind you want and imagine that the price is going to go up by something noticeable. So I don't know, I'll pick a bottle of soda. I want to say it's around $1.89 or $2. Let's say it goes up to $2.50. Well, there are some people who will no longer pay $2.50 for the bottle of soda. And so as those sales go down, you have less money. To the extent that you have any money, you're paying it for compliance. Where you're probably not putting it is into research and development. Probably not as quick to launch that new product that you kind of felt sure about before, especially now, to go back to the setup for the last question, when you're already struggling to make ends meet. So I think number one, the costs definitely weighs negatively against innovation. Number two, the law is more than a lot of laws, is inflexible in its application. And that's simply because of the way it was drafted. And the way it was drafted is simply because the legislature was put under the gun by a millionaire who said, do the law this way, or I will force a ballot initiative, and then you will have no flexibility whatsoever other than to take that language in the ballot initiative and make it law. That is to say, it just becomes law. And then you can't correct it, legislature. So you decide if you want to be stuck with that, and we'll see what passes, or be stuck with this, which I'm giving you now the same thing. And that threat continued all the way through passage. Well, one person's vision of how privacy should operate. No companies got to give their input into how this would work. Individual citizens didn't get an opportunity to talk about better ideas or other ideas. One of the things I learned long ago, doing technology and innovation policy, is one of the very worst things you can do in a law is to expressly list a type of technology. So imagine a law that said information from a doctor's office can only be sent by a fax. Oh, well, guess what? There are such laws. And to this day, there are doctor's offices in many states who are some of the only people in the country with fax machines, because whoever they're faxing have them, and whoever from whom they need to receive faxes, that's why they have one. And so they're locked into a particular technology. That's a little bit like this law. It's locked into one point of view from one person, completely inflexible because of that. The other thing I would say, and I think people don't consider that often, is while it's really easy to get our heads around innovation in technology, we see it all the time. You buy a phone and you go to the store 6 months later and there's a new phone with some kind of new thing. There's 100 new apps in the app store every afternoon, whatever. We're used to seeing that. I don't think people think about the innovation in public public policy in the same way. And yet, the reason that we have been able, I would argue, to have democracy for so long, and that we have a country that is so resilient in its fill in the blank, whether it's being able to stop and suddenly take a look at criminal justice and figuring out how do we reform it to make it better for all people, et cetera, is because you have flexibility in how policy is made and how policy is done. The way this was done strips away the ability to have much flexibility, because you've got this same threat of, if you change the law, then we're simply going to make it a ballot initiative, and then you're going to be stuck with whatever that is. And then I'll pick one final example, and that's in business modeling. So there are probably 100 examples out there where this law would be a challenge. An issue that is they hope to correct, or they think they're going to correct in an update to the law, but it's all about if you're a preferred customer, let's say, some kind of a customer reward program. Let's say you opt out of wanting your information collected, or you don't opt in, which would be true under the new proposal. Can you still, when the law says you can't discriminate against somebody because they won't let you collect their information? Well, they want to, if you buy a popcorn every time you're at the movie theater, they would like to reward you with a small popcorn. They're going to hope to upsize you when you go to the counter to buy that, or to get that free small popcorn. But they're giving you something in a situation where you understand you are giving them something as well. So that's not allowed now. So there are any number of ways that innovation, both within the privacy sector, so to speak, and then outside of it, are pretty dramatically impacted.
Bartlett, many have argued that laws like CCPA are very difficult to implement because the internet doesn't stop at the state line. Explain how the global nature of technology and online commerce make it very difficult, if not impossible, to be a California-only standard.
So this one, I think, is so simple in its explanation that I think I just want to go to the example. Why do I think it's simple? Because even I understood it when I first heard it so many years ago, and it has stuck with me ever since then. So there's a gentleman named Vint Cerf. Back in those days, I believe he was working at MCI, and I was lucky enough to be in a small group that he was a new thing called the World Wide Web, the internet, how it was going to work, and its importance and whatnot. And I'll say, at least for myself, most of us barely understood the importance, but he was fantastic in explanation. And he was describing to us, what does it mean when you send an email? The same thing applies to a website. And that is that the information, imagine you were sending a postcard or a message across the country. And instead of writing it in a letter and sealing it in an envelope, what I did was wrote one letter on each postcard, and each postcard had a number. And so when you received all these postcards, and of course the mail system, sometimes mail goes north, sometimes it goes south, sometimes it's on a truck, it's on an airplane, it takes different times, it goes different ways to get to you. When you get all these postcards, you assemble them based on the numbers, and you see the letter written on each one, and poof, you've got my message once you've gotten all the postcards. That's how information travels across the country, around the world. So there is no email. I don't write my email and say send to Tim and Roe, and that it goes through a pipe as you remember the tubes that would be in department stores where they'd put a letter in and the vacuum would suck up the tube and it would go to the third floor and you got the message. This is all broken up and sent out across systems, most of which are privately held, and these systems have agreements with each other, and some take data and some do it this way and some do it that way. All this data is broken up and then it resolves itself at your computer where you go, aha, message. In that process, things don't just stay in the state of California. They don't stay in the United States. They go all over the place, and it's virtually impossible to know when you're sending a message where they're going to go to resolve as a message to you. One last quick note, and that is that the web works exactly the same way. People often say, if I went to that website, well, it actually turns out websites come to you, and they come to you in that exact same fashion I just described. And then sometimes they're actually stored on your computer, and if not there, they will be stored on a location very near to you, as opposed to at the corporate headquarters of wherever the company is based. And so in all of these cases, whether you're going to look at a website, whether that website is coming to you, whether an email is coming to you, it's happening literally. That's where the web notion comes from. It's happening all different jurisdictions all over the country, and frankly, all around the world.
Bartlett, one of the common advertising techniques in a sort of a sappy commercial is, but wait, there's more. And, we have even more uncertainty looming thanks to a ballot measure that we're going to vote on in November, thanks to the same millionaire you were referencing earlier. And the proponents of this measure want to go even further with what's being dubbed CCPA 2.0. And if passed by voters, businesses could have to start adjusting to a whole bunch of different rules just months after CCPA 1.0 took effect. What would CCPA 2.0 do if it's enacted, and how would it differ from CCPA 1.0?
Yeah. So, hey, if we've already got uncertainty, let's just keep everything up in the air for as long as possible. You're right that if 2.0 were to be put into effect, that there would only be a matter of, I can't remember the exact time off the top of my head now that I say this, but it's not very long between this time that you're trying to be compliant with the first version and now you have a second version. And there's some pretty aggressively different approaches in the second version. I'll do a compliment to start, and that is, at least in version 2.0, they are expressly admitting what I've said earlier, and that is one of the goals is that they're addressing some of the ambiguity and unintended consequences of the first version. So why are we enforcing this first one? Because we're now admitting that there is ambiguity and there are a lot of unintended consequences. So they're trying to clean some of those up. We could have, they really are cleaning them up, but I'll at least give a hat tip in the direction that they are trying, and I will assume best intentions there. But for the rest, it's not nearly as good of a scorecard. So consumers, as opposed to opting out, as we discussed earlier, consumers would now opt into having their data collected. So this will be yet another redesign of websites and new signals. I can't think of what word would be better, but new signals for the consumer to have to pay attention to as they're logging in, maybe purchasing something, maybe just looking for information. There's an increase in fines because I guess we think that tens of millions of dollars isn't enough. So we're going to ratchet up those fines. There is a new private right of action, which is to say individuals can bring suits against companies if a company fails to maintain reasonable security measures. This is another way of saying that the costs are going up. And then I guess one other top line thing, and probably the one that I've focused the most on, is that it creates yet another new government agency fully imbued with enforcement ability. And its only reason for existence would be of collecting scalps of companies that didn't fully comply. 1.0 or the 2.0 version of CCPA.
So they say that as California goes, so goes the nation. That's often the case on policy, both for good and for bad policy. So what is the end goal of CCPA supporters? Do they ultimately hope to get a federal version of the law enacted? And what would a national version of California's law look like?
I would like to think that what their real end goal is that they want to help California consumers. It is cynical, don't you think, that they would bring a law in one state to try to force the federal government to act, and yet that is exactly what they claim that they did this for. The country hostage, they're certainly holding California companies hostage just to force the federal government to act, to put some kind of privacy law. It's not a little crazy to me, it's a lot crazy to me that one thing after another, one organization after another seems to be getting weaponized in this very ugly way. That's exactly what happened to the ballot initiative process in California. It was weaponized. Now this law is being weaponized to try to prod the federal government to act. And there's a baked in profound level of ignorance in that strategy of understanding how quickly a state might act or react, and then how quickly the federal government might act, react, or all of which are real good chances in Washington, D.C. Do I think that they want a federal law? Yeah, I think that is their hope. What would that look like? I would like to think that there would be a lot more input, a lot more data put into before you started the writing process, and real thought given to what are the consequences, so you don't have a bunch of unintended consequences. The policy choices might not end up being what I like or you like or someone else likes, but at least if they're done thoughtfully, I can at least give them that. What is crazy here is that you can't even give them thoughtful consideration. It was, again, one person's vision kind of crammed down the throats of the process, crammed down the throat of the process that Californians are now having to live with, to the tune of, again, as we mentioned, $55 billion in less innovation.
Bartlett, as we close, here's a philosophical question for you. Everyone wants to see their privacy protected, both in person and online. So if CCPA is not the answer, what would your vision be for a more free market way to protect the privacy of Californians and all Americans when they go online?
And I think you're right. And I should make sure to say that despite criticisms I have of the process and the outcome of what California has done, I am in no way adverse to privacy protections. I actually am very much, I think of it broadly. And I think that whatever the privacy protections are should be broad. So what does that mean? Well, if we're going to have privacy standards, then let's have privacy standards. And it's not just going to apply to Walmart, it's going to apply to the California government, the federal government. They should follow the same or stunningly similar rules, maybe with some nod towards the fact that the government might have different processes and procedures for what they're collecting and how they're collecting it. But I think the same rules should apply at the end of the day. So that to me would be number one. But in general, I think it should be a light touch approach, as light as we can do. There should be flexible rules. We should create a framework that encourages innovation and that encourages, frankly, compliance, if that's really the goal, if we really want to have privacy protection for everybody. And we should also, on the other side of that, we were talking about how strict the enforcement is. We should also think about flexible enforcement. Now, that doesn't mean you choose whether it's enforced or not enforced. But what it means is enforcement the cudgel, or is it we want compliance, and so we're going to set up a system that incents the compliance at every step? Do we have a system like with the FTC? They already have authority in the privacy area. They typically are able to resolve things with companies and set standards and whatnot in a way that is much more flexible than having strict application of enforcement broad. In fact, so much so, the FTC has been thought of as a place for a long time now as where privacy, one, should be dealt with at the federal level, and it does, but where maybe more resources should even be given to the FTC so that they could envision actually having a nationwide privacy standard. I think these are all things that need to be thought of, they need to be put on the table, and they need to be worked out. The good news is that process is underway. That strikes me as the right process that will likely lead to a better outcome and likely a more free market outcome than, again, one vision crammed down the throats of folks. I think there would have been a more free market outcome, frankly, if the California legislature had even just been allowed to operate in this space and to figure out what works. They would have heard from industry and from individuals who said, yeah, but what about this? And yeah, but I live like that. And oh yeah, don't forget about us over here. Even that would have been an improvement. So I think there's tons of ways to improve on California. And almost all of them would be more free market. And almost all of them, more importantly, would end up helping individuals and the economy as opposed to being a challenge to individuals in the economy.
Thanks so much, Bartlett.
Thank you for having me.
Special thanks to Bartlett Cleland and to my colleague Tim Anaya. If you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, Stitcher, TuneIn, and now iHeartRadio and Spotify. And also special thanks to Dana Beagle of Dana Beagle Designs. You don't know her on the podcast, but she plays a huge role in getting the podcast to you on all of these platforms each and every week. So thank you so much, Dana. And when you're on these platforms, don't forget to give us a big 5 stars. And if you don't subscribe to any of these platforms, you can still listen on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks again. I'm Rowena Itchon. Hope you come back again for next round with PRI.